Hi, and welcome back to the Business Career College video series. In this video, we're going to look at part 2 of our Introduction to the Canadian Legal System. And specifically, what we're going to look at here is we're going to follow roughly the path of flow, though we're going to simplify it a little bit, of a court case, how this might actually look. So we're going to have two entities here. We're going to have Fred, and then we're going to have ABC Insurance Co., which we'll just call ABC from here on. And so what we have is Fred and ABC Insurance Co. have entered into an insurance contract. Now we're going to deal with contract law in a later video. But for now, we can see that Fred and ABC Insurance Co. have entered into this insurance contract. This creates a relationship between the two. Now, at some point down the road, let's say that Fred finds himself in a position where he feels that ABC Insurance Co. should pay him something as a result of this insurance contract, and ABC Insurance Co. says, no, we don't feel that way, so we have maybe a denied claim here. And this denied claim then brings us to insurance legislation. So almost certainly we would end up dealing under the Provincial Insurance Act for the province in which Fred is resident. That's almost certainly what would happen. There are some possible exceptions to that, but that's almost certainly how this works out. So Fred says, I'm not satisfied with this. He tries some informal means of resolution. A lot of times today, the courts won't entertain Fred's claim unless it looks like he has tried his informal means of resolution, and there are all kinds of these. Most insurers have an ombudsman, and then there would likely be a provincial insurance ombudsman as well. Most provinces have one. So he tries the various ombud services that are available, and he does not get any satisfaction out of that. So now, what he might do is he might pursue a tort. And a tort refers to a harm caused to Fred's wealth, property, person, or dignity. In this case, he would demonstrate most likely that it's harm caused to his wealth. And a tort simply is a fancy way of saying a lawsuit. Tort is from the French, literally for harm. So this is our lawsuit here. Sorry, I guess those quotes are not appropriate. And this still might result in an informal resolution. It's actually quite common in our legal system today, owing especially to the costs associated with going to court, that we would maybe make an out-of-court settlement. So we might settle out of court, but that's not that's not how we want to resolve this here, because we want to see how the whole system works. So what happens now is, before we go to court, we're going to go through the process of discovery. There might even be a little bit of negotiation that happens here. And discovery is simply when we have a sharing of evidence. So this is where both parties present evidence, and typically it's done in a somewhat informal setting with a reporter, with a court clerk there to write this all out, but not under the eye of a judge or anything like that. So then we end up, assuming we can't make a successful out-of-court settlement, we end up in court. And we would end up at what's called the court of first instance. And that simply means the first court that you go to under ordinary circumstances. In this case, the court of first instance, depending on the province that you're in, is going to be called the Superior Court, or somewhat misleading, the Supreme Court, or maybe a Court of Queen's Bench. These are the terms we normally apply here. Other examples of courts of first instance include, for example, family courts or traffic courts or most criminal courts are courts of first instance. So this is just the first place we're going. Estate courts or probate courts are also courts of first instance. And once we're done here at the court of first instance, or so what will happen here at the court of first instance is both parties will present their evidence. And of course, we're assuming that there are lawyers involved here. So they're going to present their evidence before a judge, and then that judge makes a determination. A ruling. And this ruling is going to be based on a couple of different items. So the judge is going to look at the laws as written. The judge will refer to statute law. And if there's a very clear set of facts, so this is where we get into a very important legal concept called the questions of fact, or a question of fact. So if the facts in Fred and ABC's case match up to something that's described very clearly in statute law, the judge probably has a fairly easy time of this. However, that's not that common. It's quite common that the facts are not as clear as what we see laid out in statute law. And that's where we would refer to common law. And this is where the judge is going to look for a precedent. And once again, we're going to look for a precedent that matches the facts in Tom's particular case. And what'll typically happen here is, in Fred's particular case, I apologize, Fred's lawyer will make an argument that says this precedent applies. ABC Insurance will make arguments that say this precedent applies. They'll both argue back and forth about which precedent is appropriate. So now we're going to come to a ruling. So the judge makes a ruling based on these factors. Now, we may end up with, and it's quite likely we do in fact, end up with somebody who's dissatisfied here, somebody who feels that this ruling is incorrect, and that's where either Fred or ABC Insurance Co. might file an appeal. And this takes us to the next level in the provincial court system, which is the appeals courts. The appellant courts or appeals courts. And what happens at the appeals courts, it's not going to be a new case here. Basically, we, in most provinces, have 3 senior judges. And these 3 senior judges will review the work done by the judge at the court of first instance. So they'll review the first judge's work, and they'll say, hey, did that first judge properly apply the questions of fact here? That is, were the facts properly applied, and how did they match up? How did those questions of fact match up with the statute law? Was that properly applied? And how did that apply back to the common law? So these judges are going to review these factors and make a determination and say yes or no, this works or this doesn't work. Now, generally, that's where we stop. Generally, the appeals courts will make a ruling, and that's where most cases stop. It's rare, quite rare in fact, but it is possible that we could have a further level of appeal. And in this case, if you're going to appeal, you're going to appeal to the Supreme Court of Canada. And the Supreme Court of Canada says, okay, we only look at a small number of cases each year, somewhere less than 100 cases that come from the provincial court system are seen by the Supreme Court in a given year. And what happens then at the Supreme Court is they will choose cases based on national interests, or if there's a constitutional question, or sometimes the Supreme Court chooses cases where there's a gap where they interpret there to be a gap in legislation, where they say, hey, the legislators at a particular level should identify this gap. We're going to point it out for them that there is this gap. We're going to see that case. Now, this is a very expensive process, quite cumbersome, quite time-consuming, not the ideal way to settle most matters, but it does happen that some cases end up at the Supreme Court. Now, once we are at the Supreme Court, here these judges will see evidence and they will treat the case as if it's a new case. They'll see everything from scratch in most cases, and based on that, they will make a ruling. And because these rulings almost inevitably create a precedent, and that precedent generally applies in all provinces that have similar legislation, so because of this, the Supreme Court goes through a lot of work when they're writing their decisions, and we'll see this, that the majority decision, that is the ruling decision or the winning decision, there'll be a raft of legal thought behind it, and that legal thought is all presented so that anybody can go and look it up. And then even the minority judges write a very long decision, typically stating all of their opinions on the matter and why they feel that the decision should have gone the other way. This becomes very important because of the weight that we give to Supreme Court of Canada decisions. So I hope this helps to understand our legal system. We don't want to end up in court. You can see that it can be quite an onerous and expensive process, but it's good to understand this process, and I think it does help to understand the relationship between statute law and common law, what we really mean when we talk about a precedent. I hope you enjoy your continued studies. Thank you very kindly.